Hi. So since Mr. Pawan Khera's anticipatory bail has been making rounds on the internet, I decided to go ahead and take a look at the legal regime that governs anticipatory bail. And I did a comparative analysis of the erstwhile law under CRPC 1973 and Bharatiya Nagarik Suraksha Sanhita of 2023. And I found a very interesting gap, chasm, or a question as you may call it. And I thought I should share it with you so you can tell me what do you think about it. Under the erstwhile regime, we had Section 438 of CRPC which governed anticipatory bail. Under the new law, you have Section 482. On the very face of it, Section 482 is much smaller than Section 438 because a couple of subsections that were there in 438 have been done away with in 482, like subsection 1A, subsection 1B. Now, even a part of subsection 1 of 438 is done away with in 482 subsection 1. So if you look at 482 subsection 1, it is comparatively smaller in size compared to the erstwhile subsection 1 of 438 CRPC. What has been done away with in subsection 1 is a few considerations like what to consider, what will the court consider while giving the anticipatory bail. It will look at the antecedents of the accused, it will look at the nature and gravity of the offense that he has been accused of, etc., etc. But all of that will still stay intact in the new provision because it has one small phrase in subsection 1 which says that if it thinks fit. So anyways, the court is going to do all of that balancing with different grounds, so it doesn't bring a lot of change. The major change that I feel, a major gap or a question that came to my mind was with respect to the proviso of subsection 1 of section 438. That proviso said that once a person applies for anticipatory bail and if his anticipatory bail is rejected, or if a next date of hearing on the application for anticipatory bail has been fixed without giving him an interim anticipatory bail, which is what Mr. Khera got, then the police has the freedom to arrest that person right there in the courtroom without a warrant. Now, this point about without the warrant is where the question arises. In the new law, you don't have this proviso. So in the new law, nothing says that if your anticipatory bail application has been rejected or you have been let go with a next date of hearing without an interim anticipatory bail, then the police cannot arrest you without warrant. Now, how does this become relevant? In the Code of Criminal Procedure or Bharatiya Nagarik Suraksha Sanhita, you have two sorts of offences. You have bailable offences and you have non-bailable offences. Clearly, Section 482, as it says itself, is applicable on only non-bailable offences. But then you also have another categorization of offences, which is cognizable and non-cognizable. Simply put, in cognizable offences, the police, while investigation, can make arrests on its own without needing a warrant from the magistrate. But in non-cognizable offences, the police needs a warrant from the magistrate to make an arrest during the investigation. Now, Section 438 of CRPC was applicable on both cognizable and non-cognizable cases, provided that's a non-bailable offence, and same as the case with Section 482. Now, how did the proviso under subsection 1 of 438 help was that? So once your anticipatory bail has been rejected, the police was there in the courtroom, you hear the rejection, and immediately the police can go ahead and arrest you. And they can make this arrest without needing a warrant, irrespective of whether that case was a cognizable one or a non-cognizable one. So a new point was being given to the police. That is what? It can make an arrest without a warrant, even in a non-cognizable case, provided that your anticipatory bail application has been rejected or no anticipatory bail has been granted to you. So that was a new power that was being given by the proviso to subsection 1 of section 438. But in 482, you do not have a proviso of that sort. So now what does it mean? So even if your anticipatory bail has been rejected or you have not been granted an interim anticipatory bail, then if despite the police being present in the court premises, will it not have the power to arrest you if your offense is a non-cognizable one? And there are a couple of offenses in the law which are non-cognizable and non-bailable. For example, if you look at section 337, 338 of BNSS, and there are many more sections which are non-bailable and non-cognizable. So they can be applied for in respect of anticipatory bail. But once your anticipatory bail is rejected, while under CRPC, the police had the power to arrest you then and there without a warrant, even in a non-cognizable case, by the mere fact that your anticipatory bail has been rejected or that you have not been granted an interim anticipatory bail, it cannot do so now because there is no proviso in 482 which is giving the police that power to arrest you without a warrant in a non-cognizable case. So at present, the police can only make an arrest as it does normally during the course of investigation, which is that even if your anticipatory bail has been rejected, the police will still need to seek a warrant from the magistrate and come back and then make an arrest in a non-cognizable case, even if it's a non-bailable offense and your application for anticipatory bail has been rejected. Now, that is my reading of it, but maybe the Honorable Supreme Court will give us a more proper reading of it and set the law down. But till then, what do you think? Is that how we should read Section 482 in comparison with Section 438 of CRPC or not?